Welcome to Steve and Tamara Explain Corp's Law, the podcast where two entirely self-appointed experts pretend to know more than they actually know about companies, directors, shareholders, and the occasional legal catastrophe.
This is the place where we take the cases, legislation, and big corporate theory ideas you're meant to understand, and then immediately make them sound much less serious.
So grab a coffee, open your textbook, and let's get into today's episode of Steve and Tamara Explain Corp's Law. Hi, I'm Steve.
And I'm Tamara. And welcome to
Steve and Tamara Explain
Corp's Law.
We got worse than the last time.
Yes, we did.
Because... anyway, I'm not going to justify it. I'm terrible at the intro.
No, it's because you hate the name, I know. He tried to introduce a petition to get our viewers to change the name.
Can we do comment... help people do that on the comment below.
People are going to be commenting, I love the name. Tamara's a genius.
Well, I want to see that. Okay. I want the evidence. I want the proof. And your suggestions, make them kind. Suggestions for different names.
Kind only.
What would you call it, Duncan? Welcome, Duncan, by the way.
Yeah,
what name would you choose?
Steve and Tamara Explain
Cooperatives and Mutuals.
Law.
The best.
Steve and Tamara Explain how corporate slavery operates in practice.
Yes.
So we're not asking Duncan.
No.
But what we are asking Duncan about today is to talk us through one of our key corporations law cases. Duncan, which case are we looking at today?
Briggs and James Hardie from 1989.
Excellent. No, that's right. I looked it up right before we came here. For some reason, knowing the year of the cases always feels important to me, and not just because it's part of how you find them. I want to place them in history.
Yeah. I think that's a really important thing to be able to do, because when you're looking at the law, it's often point in time, kind of, what was happening at the time.
Yeah.
Why was that decision made?
So this case is younger than me, older than Duncan.
Same age.
Same age.
Same age.
And much.
Not that much.
Much.
I'm still an 80s person. Still in the same decade. It's still in the same decade.
Did you work on this case?
I was, I was senior counsel.
Great job. Okay, so Duncan, could you please walk us through the facts of Briggs and James Hardie, 1989?
Briggs and James Hardie involved an Indigenous guy from New South Wales. I think he was from Coffs Harbour originally. And he moved to get work at an asbestos mine near Byron Bay. And worked there for a decade or so, I think. And ultimately contracted mesothelioma.
Yeah.
Whatever it's called, asbestosis.
Asbestosis, yeah.
He had a claim in tort to get compensation against his employer. Won the case against his employer, but the employer, Marlew Limited, didn't have the funds to cover what he was owed.
Yeah.
So this case was brought against the corporate owner of the company that employed him.
So the subsidiary was the employer, and then
James Hardie
was brought against the parent company.
Yeah. And the question was, could he get compensation from the parent company?
Yeah. And so, if the court refused to pierce the corporate veil, then he gets nothing. He has the satisfaction of a claim in tort, but he gets no restitution.
Yeah. What are they called? Shallow pockets.
Yeah.
The employer. So really important case, and it is I think 1989 is really interesting because at that period, two things were going on. Firstly, there was the asbestosis crisis, which obviously is a really dangerous material, but big asbestos companies around the world had been covering up the dangers of asbestos, a bit like the tobacco companies had been doing, even though there's strong evidence that they knew about the dangers of asbestos since, the 40s or 50s.
Yeah.
So whilst they were engaging in asbestos mining and selling it, they knew about its dangers and didn't warn people about the dangers.
Pretty evil behaviour.
Yeah.
You really
yeah.
like
really evil behavior.
That's evil behavior.
It is evil. That is evil behavior.
So, you know,
I don't like evil.
As a descriptive word, I mean, like not that you actually like evil things.
Let's get back to this actually serious case.
Serious case.
But yeah, like around the world in the 70s and 80s, when people were contracting asbestosis, finding out how dangerous it was, they obviously began suing for compensation. That happened in America, in the UK, and Australia, a big asbestos producer. Obviously, a lot of cases in Australia as well. So that was one thing that was going on. And then the other thing, kind of in the background, is that questions were being raised about the corporate veil in the parent company, subsidiary company relationship. So there was a UK case law in particular, and some case law in Australia as well, that were raising doubts about whether parent companies of wholly owned subsidiaries should have absolutely limited liability for the acts of their subsidiary companies. So these two processes, people suing asbestos companies and questions about the liability of parent companies for subsidiary companies, kind of came to a head because a lot of the people affected by asbestosis, they were suing companies, but those companies were subsidiaries. So there was a lot of litigation around this issue, asbestosis and subsidiary parent company relationships.
And this case fits into that kind of broader frame.
Yeah, and Adams and Cape Industries, the really famous UK one, basically exactly the same. More or less the same set of facts. Yeah, so I think it was a live question whether the Salomon principle, as applied to parent company, subsidiary company relationships, would continue to apply.
Yeah.
It's a great kind of overview of the facts, but also the broader context in which the case existed.
Yeah.
Great. So we've got a really good overview now of the material facts and why this case was important, what was going on at the time. The next thing that we'd like to ask is, what were the key issues in this case, the key legal issues?
The first thing is that this Briggs case wasn't actually deciding whether Briggs would be able to sue James Hardie, the parent company. It was an appeal against limitations on time.
Oh.
The statute of limitations.
The statute of limitations. Because he'd contracted asbestosis in the 70s. And this was the 1980s.
And it was beginning to get media attention. Is that why he sued?
Actually, I haven't been able to find much information about the plaintiff. It's not entirely clear to me.
Yeah.
But he brought a claim against his employer, and the statute of limitations was deemed not to apply against his immediate employer, the subsidiary company. But then he tried to sue James Hardie. The court at first instance said no, because of the Salomon principle.
Yeah.
So then he appealed, and that was the Briggs case. And the Briggs case had to decide whether he would be allowed, regardless of the statute of limitations, to bring a case against James Hardie.
Yeah.
So this case was about whether he had a good argument that might succeed in a higher court.
So these were when you're reading this case and you're looking for the ratio, I guess you're looking at that, because that's what the court was asked to address. But then there were some other issues that they considered.
Yeah, I mean, ultimately they found in his favour. Yeah. But that didn't mean that the court pierced the court veil.
Yeah.
It meant that the court said it was possible that a court would find that
the veil could be pierced.
So it's a useful case to kind of consider lawyering in Australia because it's cited all the time for this kind of proposition, but not necessarily, when you're learning in Australian legal reasoning or foundations of law, like in an introductory unit. What was the key issue? What did they determine? And then that becomes the law. This is an instance of when you can have a case looking at things that weren't necessarily vital to the ultimate decision, but have then since taken on a bit of a life of their own and kind of influenced the law.
Yeah, like it ultimately stood for the proposition that it was possible.
Yeah.
That courts would find that you can pierce the court.
Can you talk a little bit about that? The usual way of looking at this case, which is like tell me the issues, then the finding, and then we get to the outcome. Not necessarily the way that we look at this case. So you have the key issues, but then you have some observations and kind of legal reasoning. What was their reasoning that is relevant to our kind of discussion on piercing the veil?
They're asked to consider whether it was possible another court would find that you could pierce the veil. They didn't have to decide whether courts would pierce the veil, just whether there was an argument that could be made.
Yeah.
So the judgment is really important. They found that it was possible, that court would come to that decision. And the judgment is a great judgment by Rogers AJ, laying out some of the history of the corporate veil as it applied in the case of corporate groups. So I think it's a really good picture of where the law was at that time, how the Salomon principle works in that context.
Okay, great. That gives us a bit of insight into, what they were thinking in terms of these principles. The last thing, I guess, that I kind of think is really relevant for this case is what have been the implications, what's happened since, why is it an important case?
What's its lasting impact?
It hasn't had much of a lasting impact.
There you go.
It's good to know.
Good to know. Like, I'm glad we're talking about it.
But the door has never been closed.
Yeah.
And in scholarship, it's almost unanimous that it seems unjust that a parent company can't be held responsible for the torts of a wholly owned subsidiary.
Yeah, where they share common directors and
To push back on that, it hasn't had a lasting impact. I think it has. It just depends on how you view impact, the impact that it has. And I mean, the fact that we're still talking about it, it's still in all the key textbooks. Scholars are debating it, even, picked up sometimes in, by judges discussing these kind of issues. I think that the fact that it's kind of raised in those, in that context shows that there's still this kind of debate. It's still a little bit unsettled and people aren't necessarily satisfied with the current situation in the law. And this case is often the one that you go back to as this is where they started to kind of really consider these kind of things in Australia. I mean, they were considering them before, but the starting off point.
Yeah, I think that's so true. Like, I don't think it hasn't had effect on the law.
Yes.
Yeah.
Since it was decided, but its arguments remain legitimate.
Yeah. Why didn't Briggs sue James Hardie?
Well, he did try and sue James Hardie. This was that case. He was trying to get the right to sue James Hardie.
And the court found in his favour.
They found in his favour that he wasn't limited by the statute of limitations to sue James Hardie.
Right.
So he could sue James Hardie if he wanted to. I don't know why he didn't. Yeah, I don't know what happened. I would love to know what happened after.
Maybe he died.
Maybe he died. Like, why didn't his estate go on?
Because we saw that with the VAT
I'm sure that there's an answer to that.
Yeah.
I'm sure someone will comment below. In addition to our name, I'm sure there's an answer.
As senior counsel, you really should know this.
Like, people are going to, like, if anyone ever watches this, is just going to get that grab and, like, say that I'm claiming I was senior counsel in that case. I will not.
I mean, you were, like, 4. So. 5, 6,
When it started, I might have been 4.
But yeah, I would love to know. Yeah, why he didn't go on and what happened to him.
Because I always teach the McCabe and BAT case in legal ethics, which was against the British American Tobacco. So similar, although it involves some great ethical issues around Clayton Utz destroying documents.
Really?
Yeah. Also not rape behaviour. And in that case, McCabe did die before the litigation finished and her estate took over. But it was a bit sad because eventually the court found, for unrelated reasons, against her.
Well, that's a sad note to end on. Sometimes we don't have good outcomes in the law.
True.
And on that note,
thanks, Duncan.
thanks for joining us to talk about this. Really, it's a I know we kind of joke about, but it's actually a really sad kind of case. And the fact that we started this conversation with you saying that it was happening in a lot of places around the world at this time just shows how, even when you think more broadly about corporation, bringing back to some of the other discussions that we've had, this kind of conduct, how it's happened throughout history and not just in asbestosis, how these kind of things happen in society and
corporate wrongdoing.
Corporate wrongdoing, kind of thing. So a really important issue that's still kind of debated ongoing, and this is a really important case in that debate. So thank you for talking to us.
For me, like, looking at the corporate veil, I think this is like, if you read any case, you should read this case because it sums everything up so nicely. And like we've said, it shows what's possible. In this area.
That's a more positive note.
That is a more positive note.
Like,
Thank you.
How the law can positively be, even though it's not at the moment.
Thank you for that.
Thanks again. All right, thanks, Duncan.